if I can invite the individuals who are on our final panel to come on up, we will continue the conversation with just a bit of further reflections on these issues, with the theme being striving for peace through justice today, perspectives on the International Criminal Court. I suppose we'll take down the screen. I'll just begin as the panel is assembling to introduce our moderator. Rosa Celorio is our Associate Dean for International and Comparative Legal Studies. I sometimes introduce her as the center of the universe for our program because so much runs through Rosa, but Rosa will be moderating the panel today, and although I see the panelists leaving the room.
But they're coming back.
Hopefully they're coming back.
They're coming back.
Rosa, I'll hand it over to you. I'm thinking maybe we might take down the screen. Yeah.
I'm so sorry. Hi, how are you? Nice to meet you. Well, first of all, can you hear us well? Yes? Well, first of all, good afternoon. Thank you so much for being here. For those of you that do not know me, my name is Rosa Celorio. I serve as Associate Dean for International and Comparative Legal Studies here at GW Law School. Thank you, Sean, for that very generous introduction. And I have to say, this is such a wonderful day for our program, you know, for the International and Comparative Law program, for a number of reasons. One of them, we get to honor and remember the incredible legacy of Professor Tom Bergendahl, who we all learned so much from. Many of us, in our human rights careers, we have applied his work, you know, and the legal standards that he developed, and we continue to do so. So it's a tremendous honor to be able to honor his legacy today and to be able to work alongside him as well here at GW Law School. And I think it's also absolutely wonderful to have Judge Obo Osuji here, you know, introducing this notion of a right to peace, you know, making the argument that, you know, this can be treaty-based. You just made my human rights class much more harder today. I just want to tell you that, and I want to thank you for that. You know, it's amazing the work that you do to further peace and justice and human rights. I want to salute that today. And I also want to say how honored we are at GW Law School to have incredible thinkers like Professor Murphy and Professor Steinhardt, you know, and many of them that are here today, and many of them are seated at this table, actually, to be able to have this kind of dialogue and convening here at the law school. You know, and without further ado, I want to tell you about our panelists today because I'm actually very humbled to be seated at this table today. These are incredible thinkers, not only in the areas of international law and human rights, but also international humanitarian law, and they all work very closely with International Criminal Court as well, so there's a lot to discuss today. So I want to start by introducing them, but many of you know them already, but I will introduce them anyway. We have Professor Laura Dickinson here, who's the Oswald Simister Kuklev Research Professor of Law and Professor of Law at GW Law School. And her work focuses on national security, human rights, the law of armed conflict, and foreign affairs privatization. She has authored numerous articles and book chapters, including scholarship that has appeared in the American Journal of International Law, the Yale Journal of International Law, the NYU Journal of International Law and Politics, the William and Mary Law Review, the Emory Law Journal, and also the Southern California Law Review. And I have to tell you something. She produces some of the most fascinating scholarship that this institution issues in the area of international law and human rights and international humanitarian law, and I highly recommend her courses as well, okay? And she has a very lengthy introduction, but you know, for purposes of time, I can't read her entire bio. And the same for Professor Buchwald. You know, Professor Buchwald has a long career at the State Department, including as a lawyer heading the Office of Political Military Affairs and the Office of United Nations Affairs in the Legal Advisor's Office, and as Ambassador for Global Criminal Justice. Many of you know that he's currently also serving in the United Nations Committee Against Torture in Geneva, and very relevant for us. He also teaches at GW Law School, classes in the areas of international law, international criminal law and international organizations. And we're also incredibly honored to be joined by Professor Alka Pradhan. You know, she's a human rights attorney specializing in litigating the effects of torture on fair trials, most notably before the Guantanamo Bay Military Commissions in U.S. versus Khalid Sheikh Mohammed et al. And the International Criminal Court, where she's Associate Defense Counsel for Al-Hassan Ag Abdul Aziz in his case arising out of the situation in Mali. She's also an adjunct professor for University of Pennsylvania Carey Law School, and she's also one of the co-authors of the Mendez Principles, which aim to end coercive or torture-driven interrogation practices around the world. There's much to talk about this afternoon. We're going to be talking about that connection between justice, human rights, and peace. We're talking about issues related to Russia's invasion of the Ukraine, potential U.S. cooperation with the International Criminal Court, priority human rights concerns, which affect the work of the International Criminal Court today, steps, that the International Criminal Court can take to strengthen its credibility, resources, and effectiveness, the establishment of tribunals to prosecute the crime of aggression, and many other issues. Without further ado, I actually want to start asking Professor Dickinson the first question of this afternoon. So I'm going to start, especially because you organized something very important for us, a few months ago. And I just want to say, in your work as a professor and scholar, you have offered priority attention to Russia's invasion of the Ukraine, of course, and the ongoing global alarm over atrocities perpetrated in the context of this war. In this sense, you led a workshop here at GW Law School on February 3rd, 2023, to discuss possibilities and challenges linked to U.S. cooperation with the ICC in the context of Ukraine. If you could please share your thoughts on the relevance of the ICC to address atrocities committed in the context of this ongoing war and critical opportunities.
Wonderful. Thank you, Dean Celorio. And I just want to say, what an honor it is to be part of this magnificent and extraordinary event today here at GW Law School. So I'm going to respond to your question and say a little bit about the relationship between the United States and the International Criminal Court at this moment. I think we're at a really interesting and promising moment in that complex relationship. Of course, the United States is not a party to the ICC treaty and at times has engaged in acts that are quite critical of the ICC, and indeed at the end of the Trump administration, we were at a low in that relationship with sanctions imposed on court officials. The beginning of the Biden administration, those sanctions were lifted, and there was really a reset in that relationship. And then for the ICC's part, the new ICC prosecutor, Karim Khan, prioritized certain elements of the Afghanistan investigation, which of course implicates the United States. And so that kind of helped reset the tone. But in the wake of the horror of Russia's aggressive war in Ukraine and the atrocities committed there, there's actually a ray of hope, perhaps to use the late, great Professor and Judge Bergenthal's words, with respect to accountability and the United States' relationship with the ICC. Because I think we're at a moment where there is actually such collective outrage about the Russian atrocities in Ukraine that there is bipartisan political consensus for greater cooperation with the International Criminal Court, and in particular with respect to the Ukraine investigation that the ICC is conducting. And as Rosa mentioned, last February at GW Law School, we hosted a quite diverse bipartisan group of experts to assess a few ongoing issues related to U.S. cooperation with the ICC. Many of those participants, some of those participants are in this room. I had the great privilege of helping organize this event with my colleague Dean Celorio and Ambassador Buchwald, Professor Murphy, and Professor Calabro as well. I am, in response to your question, going to say a few things about some really remarkable, I think, conclusions or near consensus points that emerged from those discussions, which were held under the Chatham House rule and not for attribution. But we have a wonderful report that is published by West Point Press that kind of summarizes these conclusions. And so I just want to share sort of 2 key points from those discussions. The first is that in the workshop we looked at some new legislation that was enacted at the end of last year that the workshop participants concluded lifted virtually all legal restrictions on the United States' ability to cooperate with the ICC. There is legislation in place, including the American Service Members Protection Act, which has put restrictions in domestic law on the U.S. ability to cooperate with the ICC. Now, there has been room for cooperation even within that earlier legislation, and the U.S. has at times provided various forms of support to the court. But it's quite significant that at the end of last year, this legislation was enacted that really lifted most of the remaining restrictions on the U.S. ability to cooperate. And the consensus in the room was that that's what that legislation does. And I just want to emphasize again how significant it was that this legislation was enacted, right? A reflection of this bipartisan moment. Congress is not able to do much of anything these days, but it was able to do that. So that's really the first significant conclusion from this report. The second, I think, significant conclusion that I want to emphasize from the discussions is that the near consensus was that it is time for the United States to drop its long-standing objection to the fact that the ICC can assert jurisdiction over the nationals of non-party states. This is a long-standing U.S. objection. Ambassador Sheffer, when he was negotiating the text of the Rome Statute, right? This has been a long-standing U.S. position. But the consensus was that it's really time for the U.S. to let go of this. And I think that was really quite significant. And reportedly, that objection was holding up U.S. ability to provide tangible support to the ICC in the Ukraine investigation because, of course, Russia is not a party to the Rome Statute. So it's significant. This is what the workshop participants thought. And interestingly, this past July, reportedly, the Biden administration has said that it will do information sharing with the ICC, and this is really a quite significant step. So finally, coming out of this, what should we be looking for? What should we see coming down the pike? I think, the question is how much will the United States actually support the investigation tangibly moving forward, whether through information sharing, support for victims and witnesses, detailing personnel, funding, et cetera, et cetera. A lot of this is going to be hard to see. And I think the more the United States can actually make public what it's doing, I think the more durable this pathway at this moment of support for the ICC can be. And then finally on the ICC side, I think there are a few things that could facilitate U.S. support even further. The prosecutor's decision to deprioritize aspects of the Afghanistan investigation was significant. One question moving forward is, might the prosecutor adopt policies that would make that decision more durable? There's also the doctrine of complementarity, which under that doctrine, cases are inadmissible if they're being investigated or prosecuted in a genuine manner by a state with jurisdiction. The court has interpreted that doctrine in a way that makes it very hard for states to meet it, and there are many people, some of whom were in that workshop, who think that the court's interpretation of that doctrine is not really true to the original terms of the treaty. So now the court is the court; it's going to do what it does. But might the prosecutor consider a deprioritization strategy with respect to complementarity? I think that's another interesting point moving forward, but I'll stop there.
Thank you so much. And Professor Buchwald, I have a question very connected to what Professor Dickinson just presented. As you know, that relationship between the US and ICC has been very uneven over the years, but now we have new opportunities, especially based on basically, the war that we still have ongoing between Russia and the Ukraine. And I wanted to ask you in particular about legislation, right? Since the topic has been laid on this table, especially legislation removing long-standing statutory impediments, to U.S. provision of support for the ICC's work in the Ukraine. How durable do you think U.S. support for the court is, and what should we be looking for in the coming weeks and months in assessing where the U.S. relationship with the ICC is headed?
Thank you, Rosa. The world's most incredibly upbeat and enthusiastic person I've ever met. And thank you, GW, everybody at GW, for this incredible event, and the Judge Abuya Suje, and the opportunity really to participate in honoring Judge Bergenthal, who was truly, I didn't know him as well as many of the people in this room, but I knew him well, and he was truly just the most kind and gentle soul that God ever created. And I could tell stories about how he, helped me personally in some incredible situations. To answer your question, I hope it's durable, because I think it's in the interest of the United States to be in a good relationship with the ICC. If you go back to the task force from the American Society of International Law that was commissioned when Sean was the president of the American Society, we spent a good deal of time listing and recounting and talking about all the ways that what it does is in promotion of what we, the United States, would want, and what most of us would want, what all of us would want. And, we went through a period of in the previous administration of ad hominem attacks, and were just completely counterproductive to what we're trying to accomplish in the world. And I think that it's very important for us to find a durable path. And so I hope the answer is yes. I think right now we're sort of in a pretty good spot, or at least the trend line. We're in a good trend line. Professor Dickinson talked about the Afghanistan deprioritization, and I think it is, for better or worse, I think it's true that created political space for an improved relationship. And I know it was at the prosecutors also criticized for what he did, but it's and so there are pros and cons in what he did. But one of the pros was that it enabled a better relationship. And then the other thing that Professor Dickinson mentioned, of course, is the horrible atrocities in Ukraine, which is operating as potentially a paradigm shifting event in the way we see the ICC. The Senator Graham, who's been one of the supporters on the Republican side of assisting the ICC, had this great quote about how Putin had done what no one else could. I don't think it was possible, but Putin did it. And that's for him to rehabilitate the ICC in the eyes of the Republican Party and the American people. And, that says a lot, actually. That says a lot. And the new legislation tearing down the domestic barriers, and is really sort of, it shows that we're on a path that is, we're potentially in a game-changed situation. I think another factor that's putting us in a good spot is just the overall environment in which our foreign policy is conducted now is under an administration that believes in multilateralism and believes in working with other countries and believes in international institutions. And, one doesn't know how stable that is over time. We have a sort of certain electoral system over here. We don't know how, but that for right now, that's in a good spot. And I would say also the fact of having Ambassador Van Schok over there as a spokesperson for the cause is an incredibly opportune thing that's happened. She's an incredible spokesperson to the world, but also within the administration, which I think is really important. So all this created an environment which we saw ended up in President Biden's decision to overcome the jurisdictional objections, and to say we will, to order the intel agencies to provide intel to the ICC, which is itself an incredible event. What Laura didn't say was that on the day of our workshop, this is all as reported in the New York Times, on the day of our workshop was the day that the principals were meeting to deal with this issue. And no doubt inspired by the workshop with a certain lag time, they saw the administration saw the light. On what happens next, these are things I'd look at. Yes, for what I'd look at for. These are the things possible indicators. So the first I'd look for is how will the administration explain its support for the ICC's actions in Ukraine. Right now we have legislation that's about Ukraine. And we have an objection that's still on the books. I mean, nobody said we don't object to jurisdiction over nationals of states that are not Rome Statute parties. We're just doing this other thing in Ukraine. So how is the administration? Is it an exception to policy? Is the policy still there? Is it it's one of several issues, but it's still this kind of thing, or is it we no longer think this policy is our policy? And we don't know that yet. And I think we can look for signs of what the answer to that question is. Is this just a one-off for Ukraine? Because there are a lot of other places where you would think the U.S. would be very supportive, but the same issue, this same jurisdictional issue in Georgia, right, which has some of the same dynamic, a lot of the same dynamic of possible Russian atrocities in the territory of what was Georgia and Myanmar, which is about a sympathetic place from the U.S. perspective politically for the ICC and the cause of accountability, as you can imagine. And will there be any moves in Congress to extend the legislation which crash these barriers to assisting the ICC for Ukraine, but the barriers still are there for everybody, at this point for everybody else. I mean, it's complicated how it exactly works and everything, but basically they are taken down for Ukraine. And then, as Laura said, it won't be easy to see, but what intelligence will we share? There are a lot of issues when we're talking about sharing intelligence that have nothing to do with jurisdictional objections and so forth. There's a lot of different sensitivities. How hard will the administration fight to push forward? Because because otherwise they won't get that far, and that will be hard to see, but it's worth looking for signs of. Will we be persistent in pushing for accountability in Ukraine, like if and when there's talk of a peace deal? For sure, there will be efforts to put accountability, take accountability off the table. How will we react to that? And none of us really know yet at this point, but that's an important issue. What will happen when, some have surfaced, but more will inevitably surface of charges against Ukrainians, right? That will happen too. And how will we react to that? Will we be true to the cause, or will we politicizing it? And then the possibility of other jolts to the system. We don't know. In the ACEL report, we talked about the two sort of exogenous factors that were making for a bad political environment, one of which was Afghanistan, the other of which was Palestine. And Palestine's still out there, and that has an inevitable effect on our domestic political system. But it's hard to know it's hard to know what's going to happen, and it's hard to know how it will affect things. And that will go to the question of will the support for the ICC remain bipartisan, which is if it's going to have a long-term future, it has to be. We have to find a way to put it on a kind of bipartisan footing. So those are some of the things. I'm sure there's more, but those are some of the things I think might be indicators of what's ahead for us and how durable the relationship will be.
Thank you so much. And I want to connect with what you said about accountability and the way we're looking at the court right now, and ask Professor Pradhan, especially on the basis of your extensive human rights experience. You have this distinguished career as a human rights lawyer, some of your work you've done before the ICC, and I wanted to ask you, especially from the viewpoint of human rights, what do you think are the main concerns before the ICC today, especially in light of everything that we have been discussing?
Well, thank you, Professor Celorio, Professor Murphy. lovely actually to be back at GW, and it seems like a room full of friends and family, and literal family, and some mentors as well. I see Professor Sheffer, of course, back there.
Everyone here okay in the back?
Microphone might be
Maybe
helpful.
put the mic.
Oh, of course. I have never been accused of being too quiet, especially not in a courtroom, but let me speak directly into the mic. So I've been at the intersection of human rights law and humanitarian law for a while, and my remarks are sort of both as someone who wants the ICC to succeed and wants the U.S. to play a part in its success. And when I was thinking about this question, it struck me that that my remarks sort of fall along the lines of, if you indulge me, the discussion of the jus ad bellum and jus in bello of the court. The former being to answer your first question, the conditions under which situations are coming to the court, and whether the court is choosing to or is empowered to engage. How is that a human rights concern, right? So the ICC is not a human rights court per se, right? But it was founded on principles of inherent human rights. And because we're talking about the International Criminal Court, I see the first and biggest human rights concern as the equality of all states before the law. And beyond that, the equality of all people, the rights of all people to have their human rights protected within the capacity and the resources of the court, and the jurisdiction of the court, of course. And it's an area that is, I think, rightly of enormous concern to the prosecutor's office and to the court at the moment. As a litigator, I think the best way to stress test a system is to apply facts. And so you've heard references to the situation in Afghanistan, and I have to be the flamethrower for a minute and take a step back and look at the costs of the so-called deprioritization of the situation in Afghanistan. I should mention at this point a disclaimer that as an employee of the Department of Defense, nothing I say should ever be taken to represent the opinion of the Department of Defense, ever. And nothing I say should be taken to confirm or deny information that the government considers to be classified. So it is no secret that U.S. forces committed crimes in Afghanistan post 9/11. The abuse of detainees, particularly in conjunction with the Northern Alliance, was very well documented more than 20 years ago. It's now established fact. The initiation of the investigation by the prosecutor's office in November 2017, it was almost 6 years ago now, was an opportunity for us to distinguish ourselves from other non-parties, and we are, I think, having spent some time now, as many of you have, at The Hague, we are the most important non-party to the ICC. But to distinguish ourselves from people and parties and states who are still the subjects of investigations, and that would include the Taliban, who remain the subject of the remaining part of the Afghan investigation, and either trigger meaningful investigations here at home that may or may not lead to prosecutions. There have been none to date, and I'll talk a little bit later about what exactly justice means, right? It doesn't necessarily mean prosecution. Or allow the OCP to do their job and investigate. We did the opposite, and granted, as you all know, it was a very, very different administration at the time, and we've had a lot of changes since then. But the attitude of the United States towards the investigation, which honestly attracted a lot of surprising, in my view, bipartisan support at the time, was that sanctions were imposed on members of the Office of the prosecutor herself, and sort of the subsequent, I know we've used the word deprioritization, I think that's the word of the prosecutor, but it has also been called an abandonment of the investigation with respect to the victims of U.S. violations. It showed the world a double standard. Now, we're seeking prosecution of Russian war crimes and torture and, all of the developments over the past 6 months to a year have been nothing but positive. Particularly the possible U.S. recognition, if we're moving in that direction, of recognition of ICC jurisdiction over non-nationals, non-party nationals. Our concern, or major concern with ICC jurisdiction, or one of them, has been immunity for officials and for U.S. service members. And with regards to that, we heard a little bit from Judge Ibo Suji in his remarks about immunity. And he actually wrote something very pertinent just last year in Just Security. And I hesitate to quote people to themselves, but I will do in this situation. And what he said was, the normative proposition that state officials, including heads of state, enjoy no immunity from accountability for international crimes is not mere aspiration. It reflects customary international law that actually changed the general topology of international law since the end of World War II in order to accommodate the profound change in international law, which thenceforth stressed the profound importance of human rights, with correlative obligations upon those who violate human rights. And we have been on both sides of that equation. So look, politics are never going to be erased from the court, right? And in my view, I think in the view of a lot of people, it is frankly unlikely, given both complementarity and politics, that U.S. personnel would actually face prosecution before the court. But we need to be seen to be open to the possibility, however remote, that a semblance of equality of peoples and states before the court might yet be achieved. So in order for the ICC to succeed, we need to get on board and set an example. And I know that's what we're talking about in incremental steps. So.
Thank you so much for that. And I actually wanted to go back to Professor Dickinson on this. We're still working and talking about the ICC. And there's been a lot of discussions lately about how to make it more effective, how to make it a more resource, filled court, how to strengthen its credibility, especially in a moment in which we are giving so much limelight, to mass atrocities. If you could elaborate on that, this would be great.
Okay, yeah. No, and I'm sure my co-panelists have views on this as well. The court has been going through its own process of, self-examination, which, and there's been independent expert review, and so I think that process and that process playing out is very important. Prioritization of cases, allocation of resources, all of that. The court has faced a lot of challenges, not just with respect to the U.S. relationship, but other countries, many African countries that have threatened to pull out of the court. It hasn't been easy for the court, and the number of cases that it's been able to try has been, some would say, relatively low. So this process for the court, undergoing its own independent expert review and implementing those recommendations, I think is very significant and important. With respect to the U.S. relationship, I think it's quite right, that there's, the U.S. It's a very complex relationship that the U.S. has, and accountability is highly important. But in order to create this space, I think the deprioritization did help create the space for greater U.S. cooperation. And there's a very powerful critique of that deprioritization, which you've made. But I think that step has been a factor in the fact that we see this new legislation. We see Senator Graham and others making the kinds of statements that they're making. And so I would say I think it has been important. I think the U.S. is an important country with respect to the ICC, and I hope that we can see a durable improvement in the relationship with the court. And with that in mind, I think that another place, which I mentioned earlier, where I think, a reinterpretation of complementarity I think would help in that relationship.
Did you want to elaborate on that?
Well, I was just going to,
Microphone.
I think, I doubt they took it from us, but I think actually the idea of deprioritizing was in the ACEL report, sort of like our word too. That, of course, was, I'm not a government official anymore, and Beth wasn't a government official at the time, but it was there. And I think it's, right, obviously politics is everywhere. But the logic put forward for it was, the torture that happened, the enhanced interrogation is an abomination. It's a horrible thing that happened. And in some ways, it's the country just having sort of lost its wits after 9/11. And in some ways, it's disconcerting that it hasn't really, it's not, at least it's not seen as having done something to sort of seriously prosecute it. I think the idea of now convincing the United States, it's just not going to happen. It's just not going to happen. They did it. They decided, they had a special prosecutor, and they came up with a report, and I think it would be very helpful if we saw more of what's in the report. We've heard at times Eric Holder, who was the Attorney General, say it wasn't nothing. It was really an investigation. I think it would be helpful if we could see it. But I just can't believe that the Biden administration is going to turn back to what the Obama administration does and say, you didn't do it, you covered up, and we're going to expose. It's just not going to happen. So that's the world we're in. The logic of deprioritization wasn't, sort of like wind dated, but was not that our obligations, the obligations of the United States to investigate torture were, carried in any kind of sparkling way, but that there was stuff that happened. There were these investigations. There was this public discussion and so forth. And it's not that that suffices legally under the Convention Against Torture. That that's somebody else. That's somebody else's. And when they come to do the United States Torture Committee, I'm refused. So that's good. But the idea was that given all this stuff that happened, which isn't complementary the way the Rome Statute sees it, but there was stuff that happened, and that stuff counts when you're trying to figure out. We've got 7,000 possible cases to pursue. We're pursuing 6 of them. Is this going to be number 6 or is this going to be number 7? And the logic that the prosecutor picked up on, to the extent that it's explained why it was that logic, right? And it's not. I don't think it was put forward in bad faith. I mean, it might convince some people, and might not convince a lot of people, but it's not an irrational way of looking at things. And when people talk about, well, we have to have a world in which to make this work, to make the Rome Statute system work, we have to have a world that looks at complementarity in a broader sense than just are there prosecutions. So, and I think that part of it's true. And how it's applied to this case, I think people, it's a very unsettling case. But at the end of the day, it is true that if it wasn't for that case, this conversation would have come out very differently within the administration, in my opinion.
You have the microphone, so I'm going to take advantage of that
Oh.
because I have another question for you.
Okay.
Leaving the
I'm ready.
leaving the ICC for a second, just for a second, but we'll be back to the ICC. As you know, the Ukraine has pushed for the establishment of an international tribunal to prosecute Russian nationals. The U.S. has been criticized for its reluctance to support this effort. What do you think of all of this debate?
This is better.
You mean for aggression?
Yes.
Well, I think this is a hard issue for it's easy to be critical of my old office and the government, but I think it's a very hard issue to deal with if you're the U.S. government. So I watched 60 Minutes last night, and they interviewed President Zelensky, and he was talking movingly about these horrible atrocities, about this horrible situation that's unfolded because of this, grotesque invasion. I think they said over 500,000 people have been killed now, which is unbelievable in Europe. So it's hard to imagine a more sympathetic environment for an aggression investigation and prosecution. there are a bunch of models that could be used to sort of pursue this idea. You could have, theoretically, the Security Council could, that's not gonna happen. Theoretically, the Rome Statute could be amended so that the rules under which the Russian nationals can't be prosecuted that's not gonna happen either. I mean, some people might not agree with that, but that's just not gonna happen. What conceivably could happen is some kind of General Assembly agreement with Ukrainians to set up an international court, or an agreement between the Ukrainians and some other group of European, some other group of countries to establish an international court. That's at least plausible. And the other thing that's plausible is something with, not an international court, but a court within the Ukrainian legal system, which is what the US government said it supports. And, with international elements to sort of add to its credibility. And honestly, it's not entirely clear what it is the US government says it's supporting when it says that it supports that. What are the features of it? We don't know that. There are reasons that an honest person would be cautious about pursuing this. The idea of a Russia-specific tribunal for aggression risks being discrediting. This isn't just justice taking its course. This is something created to go after Putin. That's a talking point ready for him to use. And for a lot of people to be sympathetic to. A lot of people, not the people in this room, but there's a lot of people not in this room. And if the goal of an aggression tribunal really is to demonstrate sort of universal horror of what's happened, a mechanism that has, half of the countries of the world, whatever it is, doesn't necessarily do the work that needs to be done, right, of sending universal condemnation. And then you get to, from the point of view of the government, and they spent lots of time, wasted large parts of my life on this issue. It's hard because there's so many positions that the US government will need to reverse to be supportive of this. And, some of those are in my own mouth, in Harold's mouth. But they're there, and everybody knows that they're there. And everybody knows that we would be changing, would be able to say that we're changing the situation just because we want to get Putin. We don't really believe this. We said repeatedly, till the end of the Kampala, and to this, as far as I know, to this day, that a prosecution for aggression needs Security Council determination that aggressions occurred. We said that absent that the consent of the target state is necessary. And in fact, if you read the Kampala amendments, it's consistent with that view. The conversations I remember near the end with Ambassador Todd was, everybody agrees you need consent. The question is what qualifies as consent, and the various things with the opt-out and whether you had to ratify the amendments or something, or whether your consent in becoming part of the Rome Statute in the first place was sufficient. But what he said was everybody accepts that we need consent. Well, this would be without consent. The idea of prosecuting somebody in a national court was something else that maybe was at the margins a little bit, but not that much at the margins. In Kampala, there's one of the understandings is supposed to suggest, it does it sort of imperfectly, I think, but it's supposed to suggest doubts about whether it makes sense to prosecute aggression in a national court. I can remember, so this must have been near the time of Kampala, a conversation with a Russian colleague, sort of talking about this point, and I used I was not a good diplomat. And the example I used was, you have a case about Russia invading Georgia. You know how that case is decided in a Russian court. You know how it's decided in a Georgian court. It's not the place where you can resolve these kinds of questions because it just won't work. Bad example to use with a Russian lawyer, but still, the point is there. And to this day, you know how this would turn out in a Russian court. An aggression, if this case was brought in a Russian court, they would find Ukrainian aggression. And then the various shortcomings we at least saw in the definition that's now in the Kampala amendments are still, there's still issues that will, if nothing else, put us in a position where, well, that's not what you said then. It's just you're just sort of saying this for. Then I guess the last thing I'd say is, one thing to think about is how should we think about, right, how should we think about this fitting into our larger foreign policy objectives, right? In the article that Haruko and I wrote, one of the things we talked about was the question of whether the same peace versus justice equation has come to be applied to war crimes, crimes against humanity, and genocide, which is actually not universally accepted, but widely accepted, whether the idea that you can't provide amnesty for those kinds of crimes, they can't be taken off the table as a condition of a peace agreement. And there's UN guidance saying we will not accept recognition of an amnesty for war crimes, crimes against humanity. Whether that same logic applies to aggression. And if you look around the world, there's conflicts and there's peace treaties, and none of them say you're going to prosecute. It's inconceivable. And the question will be whether the question is, are states one in the abstract willing to take it off the table, that this is not something that can be negotiated in a peace agreement, and maybe more narrowly, are states in this case willing to take it off the table? And on that, I think from the United States point of view, I don't know, of course, I'm not in the United States, even Department of Defense.
I don't represent the Department of Defense.
I have heard that. We don't, we don't seem to have a policy of unconditional surrender, or sort of something along those lines. And on the occasions where we've heard sort of echoes of things that sounded like that, they were quickly clarified. So I'm not sure. So one would have to think about, and it may be that we should. It may be that we should. But if we don't, then this doesn't fit into that. And if it doesn't fit into the broader foreign policy objectives, it won't be. It won't have sort of sustained support within the U.S. government. That is my guess.
Thank you so much. And this connects nicely to my last question for Professor Pradhan, and it's very connected to everything that we have been discussing today. This connection between peace and justice. My question is, do you think that justice before the ICC and other international courts, you've worked with other human rights courts as well, whether you think this can lead to peace?
Sure, thank you. Yeah, no. Give me 30 seconds. I'll fix this. No, I think I want to come back just really fast before I answer your question, Rosa. I just want to come back to a couple of the comments earlier and say that I agree with regards to the Afghanistan situation, since that puts a B in bonnets. I agree, right, overall, that the abandonment of the investigation into U.S. involvement in Afghanistan spurred U.S. engagement. I don't think that's really up for debate. My point is really just to say that has a cost. It has a really, really large cost that I think everybody needs. I'm not saying no one is aware of it, but I think it needs to be said and talked about, and always borne in mind as we're thinking about how to make that relationship more durable, particularly as regards the credibility of the court. So, to answer your question, this is actually what I thought of as like the jus in bello part of my remarks about the conduct of the parties, the conduct of the OCP, defense, victims, judges during ICC proceedings from start to finish. And so I want to pivot a little bit off of what we've been talking about in terms of the U.S. relationship and just talk about the ICC and how it has worked in my experience, which is limited. Do I think the ICC's pursuit of justice can promote peace? Yes, I do. Do I think it does so now? No. But I do think that this is where states parties, and particularly the United States, can and really have to think very carefully about how we can be a positive influence. So first, I want to break it down just a little bit into how I perceive the relationship between justice and peace. And it's sort of two main points. The first is the recognition that justice takes many forms. It can be a full criminal trial from start to finish. It could be an open fact-finding investigation that does not necessarily end in prosecution. It can be a Truth and Reconciliation Commission that sometimes centers the victims more than a trial can. And sometimes a trial at the wrong time, in the wrong place, of the wrong people, can move us further towards violence and peace. And so I think that's something to keep in mind. And the second idea is that no matter what the format is, and forgiving the truism, justice has to be seen to be just, right? This is a concept that we're all very familiar with in constitutional law here at home, and I think is built into many countries' legal systems. But the ICC is just one of the methods, right, that I mentioned. It's the criminal trials. And so what does it mean to be seen to be just in that context? I want to talk some more about torture, if I may. And use as an example my client's case as really more of a counterexample. And that's the case of the prosecutor versus Al-Hassan, arising out of the situation in Mali. And I'm going to get into the facts a little bit. I'm a litigator, forgive me. Because I think it's really only through engagement with the facts that, again, you can see how the process works in reality. We are waiting on a verdict in this case, but what I'm going to say is reflected in our briefs and in our closing arguments. There are multiple credible accounts indicating that Mr. Al-Hassan was subjected to torture and other forms of cruel, inhuman, and degrading treatment over the course of a year in his lead up to his transfer to The Hague. Those accounts detail that while he was detained by French soldiers at a military base outside of Timbuktu, he was waterboarded and handcuffed day and night for 4 months and 20 days. And that treatment continued in other forms when he was transferred to state security services in Mali. The ICC prosecutors interrogated Mr. Al-Hassan 19 times over the course of 8 months while he was in DGSE custody in Mali. On the very first day of ICC interviews, Mr. Al-Hassan informed the prosecution that he had been severely beaten and he had been threatened during interrogations with both the state security actors and with the French. And at other points during the interviews, he complained of symptoms that we've had confirmed, some of them quite severe, that are consistent with torture. At no point were the interviews stopped, during which the OTP collected statements to use against him. Now, the defense challenged the prosecution's efforts to introduce specifically what we consider to be the torture-acquired evidence. And the trial chamber explained that it would not exclude the evidence because, in its view, the prosecutors did not collect it, quote, by means of torture, as in they did not torture him themselves. We have maintained that the issues of torture evidence in this case are critical to the fairness of proceedings against Mr. Al-Hassan, as well as the conduct of future prosecutions at the ICC. Because where there are no legal ramifications from the use of torture and CIDT-derived evidence, it's just one example, the effect is to incentivize torture and to encourage impunity on the part of states, including, again, in relation to future ICC prosecutions. So this is the counterexample, right, of when the ICC may have failed in the pursuit of peace through justice. There's still a lot of hope on these sorts of issues. The first is, I'm going to put in a plug for the Mendes principles. The first is in the promulgation of those kinds of tools, like the Mendes principles and the Istanbul Protocol and the Mandela rules. Of course, the Mendes principles are a set of guidelines governing the conduct of effective non-coercive interviewing. And, I was lucky to be able to participate in the drafting of the Mendes principles, and I jumped at the chance in part because of cases like this and my other day job at Guantanamo. Because it's exactly these sort of fair trial issues that eat away at the idea of justice when we're talking about that nexus between justice and peace. It's one of the features that prevent the court from moving us along the spectrum towards peace. And so the ICC must be open, and the United States should be open as we craft a way forward in our relationship with the ICC to promoting and using the tools at their disposal. And this, you know, the part of that hope is, again, the hope for increased involvement by the United States. I sort of swore I'd get through one presentation without mentioning Guantanamo, and it's just not going to happen. Can't do it. So I will say, I just want to say that, you know, aside from the lamentable attempts to construct an extra-legal regime at Guantanamo that permits torture-acquired evidence, as the chief military judge just ruled recently in the Nashiri case, the U.S. has good, we know this, the U.S. has good domestic precedents on the 5th, 6th, and 8th Amendments. We have good practices on fair trial issues. And while we all have some distance to go, all the states party and non-states party, as the case may be, on fair trial issues, on the jus in bello of justice, I think that more involvement, including that willingness to be bound to some extent, whether that's in a redefinition of complementarity, or any of the myriad ways in which you've described, is the way to improve them and sort of move towards peace. So we all have to sort of play a role in moving along that spectrum.
Thank you so much. And I actually want to thank the three of you tremendously for all of the work that you do to actually advance peace through justice. You know, you three are examples of the kind of careers we want our students to have, and we have a lot of students in the room. I also want to thank you so much for all of your words and insight today. We've learned tremendously from you. And I think we have time for one or two questions, if there are any questions from the audience. Yes, back there.
Might be long and drawn out, but I was just thinking, and I'm not an expert in international activities, but theoretically, I was asking, should we be more supportive of the efforts, like having the idea, like Trump, to meet with these international aggressors, not to dictate, but from a preventative perspective, in the spirit of Judge Bergenthal, when he said he would like to have a conversation with Mr. Trump, and having that same kind of conversation with these aggressors. And in the name of peace, as our host had said, establish a member of international communities, a Red Peace team to attempt dialogue. What would be wrong with that approach in meeting with the aggressor, not to stop them from what they're doing, but to taking the time to understand what they want, what they need, and what it would take to stop. And in the Red Peace team would just be the aggressor just trying to understand their need, being neutral, how to peacefully mitigate the situation.
Thank you. Is there any other questions? So we take them all and then we answer them? Yes. Yes, Judge.
Question for Ambassador Buchwald. In the context of the question you were addressing at some point was why is the U.S. government not supporting the establishment of an international tribunal sort of collaboration with Ukraine? And while addressing that, you indicated that the U.S. government is more favorable to the idea of creating a mechanism within the Ukraine judicial system. About that, and if you can please help me understand one difficulty there. How do you overcome the arrest warrant judgment of the ICJ? By the way, Professor Pradhan, there's an updated version of that just security thing in Journal of International Criminal Justice 3 or 4 days ago, published it. But the question for you, though, in the arrest warrant case, the ICJ made a distinction between an attempt to prosecute a high official of one state in the court of another state versus prosecuting somebody before an international tribunal. They said, well, You can do that in an international tribunal, but you cannot do that in the court of another state. How do you overcome, how does the US government, what's the argument they can see overcoming that arrest warrant judgment if the mechanism is inside Ukraine, and this would be court within, mechanism within Ukraine judiciary, where immunity, as ICJ tells us, does obtain. Now, let me add one footnote to that question. Hope you don't tell me it would be an internationalized mechanism within Ukraine, because you would have foreign people working in that. And when I hear that, I tell people, well, you can have foreigners come to you, assist you in your civil service. Doesn't make your civil service the United Nations. It is still your civil service, and you have foreigners helping out. You get my question.
Another softball question. Thanks. I was trying to sort of say, sort of lay out what are seen as impediments. I think that is an issue. I'm not quite sure. I'm not in the U.S. government anymore. It's a very convenient thing for me to say, but it's also true. I'm not quite sure what the United States thinks about the immunity of a non-state party, the head of state of a non-state party, and even the ICC. I mean, I suspect that they don't agree with that either. Even though the ICC has ruled that, I'm not sure that the U.S. government agrees with that.
But aggression is all about heads of state, isn't it? The crime of leadership. That's
Well, the arrest warrant case, if I recall, says it's saying that the it's laying out exceptions to where a person otherwise protected by immunity might be gotten anyway. And then it says, the state could provide consent, the state could prosecute the person itself. And then it says something like an international criminal court may, it doesn't really say in what circumstances, right? It doesn't say for a party or a non-state party. It's very sort of vague. And so I'm not sure that the premise that the government would start with is the same premise you would start with, that it's clearly established for even a true international court as it is within ICC jurisprudence established. I didn't go into it at length, but when I was talking about, well, we don't know what this internationalized criminal court is. Anyway, we don't know any features except that it has international support in the Ukrainian system. And, you could imagine that it requires consent at some the consent of a future government. That would still be an internationalized court. None of it sort of really fits together very well, but it also doesn't fit together very well for the U.S. Even a court court established by the by 90 countries in the General Assembly or the Council of Europe or something with Ukrainians. I'm not sure that the government would share the view that you've expressed, that the arrest warrant case establishes that question then goes away if you have a court like that, or in the ICC.
I think Todd has answered your question by saying it's even worse than you're positing. There's immunity everywhere, possibly. Who knows? So let me just say a couple words to conclude the event for today. I'll be very brief because I know everyone's been sitting for a long time, but I will say we had two objectives in convening this event. One was to celebrate and remember the extraordinary life of our friend, colleague, and mentor, Tom Bergenthal, and the other objective was to engage in a robust discussion of issues that he cared deeply about, in particular peaceful relations among nations, human rights, and accountability of governments and their officials. I believe we achieved both objectives in this event, and I'm very grateful for all of those who participated. I do want to thank, of course, the Bergenthal family for being here. I want to thank Ralph Steinhardt for his very memorable assessment of Tom, if you will, in his multifaceted ways. I think you really brought that alive. I want to thank Judge Chile Abuasuchi for his really provocative in a good way, comments to make us think about the next stage in a lot of these issues, rather than just being captured in the moment, but where might we go, where have we come from, and where might we go. I of course want to thank the families of Joe Brand and Chuck Manatt. Michelle was here earlier for their support of the lecture series. Finally, I want to thank the panelists, Dean Celorio, Professor Dickinson, Ambassador and Professor Buchwald, and Professor Pradhan for her remarks. We had a number of people who helped put this event together. The dean at the outset recognized some of them, but Dean Celorio has been instrumental in much of this. I want to particularly call out Professor Leah Calabro, who was really kind of the person. Maybe we could even give her a round of applause for all that she did. Yinghe Dai was incredibly helpful. Angelina Bonilla, Deb Gale, Shondice Kokla, all the folks in the media center who were able to make things happen here that otherwise wouldn't happen. And apologies if I missed anyone. It really is a team effort. The conversation doesn't have to end at this moment. We have a reception. So please enjoy. I'm assuming drinks are over. Oh, in the back. I can even see them. Tantalizing for the panelists to see it in the distance there. So let's continue the conversation, reflecting on both the remembrance element and the discussions that followed. Thank you, everyone, for coming.